All right, welcome back after the break, everyone. This morning we talked about damages in general, and this afternoon we're going to talk about the calculation of two specific types of damages. In particular, we're going to talk about expectation damages, how they're calculated, and the impact that expectation damages can have on business and contractual relationships. Now, damages, as you know, are calculated in one of two ways. You don't know. Number one is expectation damages. And this is the value which the plaintiff would receive had the contract been performed as planned. The other damages are restitution damages. And this is the advantage that the defendant gained as a result of his breach of the contract. So for the next little while, we're going to concentrate on expectation damages. And the English court in 1848 defined it as a situation where a party sustains a loss by reason of a breach of contract, where he is so far as money can do, he placed in the same situation with respect to damages as if the contract had been performed. So, the plaintiff in this case, the innocent party, cannot be put out even 1 cent. Okay? He has to make whatever he expected to make, the profit he expected to make on this case. Okay? But
Can you just, you please just explain the restitution damages? Those are available to plaintiff or already available to defendant?
Well, if you wait a couple of minutes, time, we'll talk about restitution damages. But again, these damages are available to the plaintiff rather than the defendant. So if the defendant made a profit of $100,000 as a result of not entering into the contract or rather performing the contract with the plaintiff, restitution damages suggest that those belong to the plaintiff.
Defendant might have not made profit.
Well,
This is that. Then how will we determine the restitution?
well, this is why we're looking at the theory of expectation damage right now. And again, if you wait 10 minutes or so, expectation damage, not restitution damage. Okay, so be patient. Now let me give you an example. In this case here, you can see on the PowerPoint, the seller agreed with the buyer to supply 100 boxes of leather at $50 a box. Contract was made May 1st. Delivery date is scheduled August 1st. All right? Let me just put that in. So 50 boxes or $50 a box, 100 boxes of leather. What's the price? $5,000. All right. Now, August 1st comes and goes. The seller, S, does not sell the leather. He defaults on the contract. Buyer has to go to the marketplace, finds Q, who agrees to sell him 100 boxes of leather at $60 a box now. Okay, so what's this costing now? What's this going to cost the buyer now? $6,000. $1,000 more. Okay? So, the question is, should the buyer be able to recover that extra $1,000 that he had to pay, plus whatever profit he's got to do? Yes, why is the buyer?
Oh, see, this is the expectation damages. He has to pay as a result of failure of seller to supply 100 boxes. He has to pay 1,000 more.
Well, let's assume that the buyer is able to process these letters or whatever, and he's able to sell it for $70 a box. He's still making a profit of
The
$10 a box.
boxes he got from Q.
The Q, okay?
That's now he got from the Q.
But again, he's making $10 profit. Should he not be? And he normally sells for $70. He's still making $1,000.
Had the seller fulfilled the contract, he would have made more profit. 10 plus 70, that's the $20.
So expectation damage then suggests that he is entitled to that profit as well. He expected to make $20 profit, not $10 profit. So again, expectation damages wants to put him, or will put him in the same position as he would have been in had the seller in this case not both. Michael?
I understand that he's entitled to $1,000, but says the extra $10 per box plus any lost profits she suffered because of the 1 month delay. How is that calculated? How do we know she lost anything because of 1 month delay?
Well, again, when we talk about evidence later on in this course, we'll talk about that. The type of evidence will be the invoices, or what their normal selling price would be. Evidence as to that, evidence as to what the total expenses were, normal evidence, or evidence as to what the normal selling price of the goods would be. Those are the sorts of things that the buyer, in this case, would have to bring evidence to trial. All right? Now, I gave you a case to read, sent it to you all by email last week, and I believe I posted it on Blackboard. Did you all have a chance to read the case?
Yes.
Yes? Zafar, do you want to summarize the case, or Michael? Maybe Michael, why don't you summarize the case? 25 words or less.
All right, basically it's a real estate contractor when made an agreement with the bank would finance the construction of condominiums. The bank defaulted on the loan, or the bank never performed the agreement, never gave the loan, and as a result, the real estate agent lost a lot of money, and he sued for loss of damages.
All right? What's the issue here? Zafar, what is the question that the court was asked to decide in this case? You read the case, haven't you? No? Mustafa?
I think I am. The question is how to calculate the damage.
Okay. How to calculate the damages? Hisham, and what did the court decide in this case?
The court decided that the award damages equal to the shortfall plus interest at the compound rate set out in the loan agreement, both before and after the
And what do we call that type of damages?
expectation.
Expectation damage. All right. So, what does this mean for business? What are the practical implications for a business? You are all business students. If you're running your business someday, you're going to be working for someone, you're presented with a situation, and you come to the conclusion that the prices have gone up. Okay, I'm going to lose money in this. So what? I don't sell. I don't have the deposit to worry about. I'm not going to.
Excuse me, which businessman are you talking about? The buyer or the seller?
We all sell. You're the seller.
From a legal perspective or from business wise?
Well, let's look from a legal perspective. This is the law.
If I'm a seller, I want to insure, and if I'm selling a volatile commodity,
Well, let's not consider the volatility. Let's say you decide not to complete the transaction on August 1st.
why wouldn't I do that
Yeah, maybe you got a better deal. Someone's going to pay you $60
instead of 50?
instead of
Okay.
50.
In this case, there might be tangible damages which suppose the parties can supply.
So what
Intangible damages to the businesses as well. Relations between the buyer and sellers, the goodwill in the market, that will also be affected by this. If the seller is not complying with the contract.
So we're saying here, what this case is saying is that there is a risk to the buyer if he does not complete the transaction. And this risk could be the complete loss of profit of his customer. You agree with that?
Customers are affected all the
Meaning the buyer has a risk that the supplier won't provide.
That's true, the buyer does have a risk that the seller won't provide. But what the common law has said here is that, yes, he can recover damages as a result of the seller refusing to complete the transaction and sell the money. Is that clear? So, in other words, he can be sued for loss of profit of his customer plus interest, as the Bank of America case suggested.
This is called expectation.
This is called expectation damage. All right, to wrap up then, if there's a breach of contract, the injured party must be placed in the same position with respect to money as if the contract had been performed as expected. So he can sue for lost profits as well as extra costs incurred